Good morning, everyone. My name is Alex Lamont, and I am the Legislative and Policy Coordinator for the New York State Association of Counties. On behalf of our President, Jack Marin, and our Executive Director, Stephen Aquario, I want to thank you all for joining us for a virtual fall seminar workshop about counties, mental health, and the criminal justice process. Our 2020 virtual fall seminar is taking place through the end of September and includes nearly 20 workshops about meeting the demands, issues facing today's counties leaders. We thank you for joining us as we move counties forward together, and we encourage you to use this hashtag counties forward together, to tweet about what you're hearing throughout the conference. This morning, we're here to talk about a state law that requires individuals who are charged with a felony and deemed unfit to proceed through the criminal justice process to be restored to competency so they can understand the charges against them and aid in their own legal defense. This cost, which was historically shared between counties and the state, is now solely a county cost, and it's estimated to cost $12 million annually. We'll hear from our panelists this morning about the history of the law, the process of restoring individuals who have been deemed incompetent to stand trial, and the recent cost shift to counties to fund these services at state-operated forensic facilities. We're happy to be joined this morning by Kelly Hansen, who is the Executive Director of the Conference of Local Mental Hygiene Directors. Kelly has over 30 years of experience in New York State government and public policy. Prior to joining the conference, she held positions in both the State Assembly and Senate, the Governor's Counsel's Office under Governor Pataki, and the State Department of Health. We're also joined by Jed Wolkenbright, Counsel for Clmhd. Prior to joining the conference, he served for many years as an associate counsel to the Speaker of the New York State Assembly in the areas of mental health, alcoholism, and drug abuse and aging. Our third panelist this morning is Courtney David, Director of Governmental Relations for Clmhd. Courtney has more than 12 years of government relations experience and began her role as Director of Government Relations in March 2018 rather. Finally, we're happy to be joined by Sharon Mcdougall, who is the Director of Community Services for Cortland County. Sharon took Cortland County's leadership in 2020 with over 25 years of mental health care experience, and she recently served as Tompkins County's mental health deputy. Before we begin, I'd like to thank Labella Associates for sponsoring this session. Labella is an architecture, engineering, environmental, and design and planning firm with over 3 decades of criminal justice experience. They create designs and facilities that energize clients and communities and are nationally recognized with a focus on partnership. If you have any questions during the presentations, please type them into the question panel on your webinar dashboard, and we'll take them up after the speakers are done with their presentations. At this time, I'd like to turn it over to our panel. Thank you so much, Kelly, Jed, Courtney, and Sharon for joining us this morning.
Thank you, Alex, and thank you to the 102 of you who are joining us today for a walkthrough of the 730 criminal procedure law and the legal complexities around this, and also an overview as to, as you'll see in our next slide, why you should care. So when we first learned that the governor's budget included in the financial plan a provision that the counties would now be charged 100% for competency restorations, we, myself and Courtney David, our government relations director, lobbied extensively to try to reverse this and get some traction, and NYSAC was with us every step of the way. I want to thank Steve Aquario and thank Ryan Gregoire for their tireless efforts and seeing them in the Capitol. At the same time, we were there knowing that we were all trying to, defeat this budget assumption. We did get some traction with the legislature, but at the end, DOB and the governor's office would have no part of it. They would not move at all. And the reason why, as Alex mentioned, is the fiscal impact and the money that they are now charging the counties. New York City, the fiscal for them in 1 year is about 60 million, and for rest of state counties, it will be roughly 24 million at 100%. So that leads us to the latter part of our discussion here with Sharon Mcdougall, who's also chair of our mental health committee, to look at possible local solutions and local initiatives that can reduce the cost and the number of 730s coming into competency restoration in an effort to hopefully serve people better and also reduce costs. So thank you all for joining us, and hand it over to Jed.
Thanks, Kelly, and thanks, Alex. Pleasure to be here with you all today. We're going to talk a little bit about, and if we could do the next slide, we're going to talk a little bit about the Criminal Procedure Law Section 30 and why you should care about it. We'll talk first about the definitions in Section 730, what it means to the counties. We're going to mention some other statutes along with 730 that are also going to be subject to these increased costs, so that you're aware of it. We'll talk more specifically about what Kelly just mentioned, why you used to pay 50% of these costs, and from now on, you're going to be paying 100% of them. Following up with a recitation of why restoration services, which are what is required by Section 730, is different from mental health treatment, and mentioning some less expensive alternatives to the county, alternatives to restoration, which would be of major savings to the county. Again, why the state is not going to be helping us, not surprisingly, this year. And then Sharon will be following up, talking about what the DCSs are seeing on the local level, the directors of community services, and ending with some proposed solutions that the conference and Sharon's work group on this issue have been discussing and will be proposing in the future. Next slide, please. The main part of Section 730 is that those defendants that come before the court where there's a chance that they might be incapacitated and therefore not be able to proceed to trial have to be identified. And they have to be identified because our Supreme Court has held that it is a violation of due process for people who are incapacitated to proceed to trial. And the definition of an incapacitated person is someone who, as a result of a mental disease or defect, lacks the capacity either to understand the proceedings against them or to be able to assist in their own defense. Next slide, please. The 730 procedure essentially, and I'm going to just kind of bring it down to very simple terms here because it has all kinds of intricacies, but in general, at the time that the person appears at arraignment, a request is made either by counsel, either the district attorney or defense counsel, or on the court's own motion because the court observes something that makes the judge feel that this person is not competent to stand trial. And the court will then order the director, according to the statute, to appoint 2 psychiatric examiners who can either be psychiatrists or psychologists to give their opinion of whether or not the defendant has the capacity required by the statute. If they disagree, the director then must appoint a 3rd examiner. Next slide. Now, these examinations are the first time it costs the county money because while the statute said these examinations, the examiners are supposed to be paid $50 for their examination and another $50 to appear in court. Any of you who have ever lived in the real world know that there's no way we can find psychiatrists and psychologists. They're going to work for $50 for a 2 or 3 hour examination and then maybe a 3-hour court appearance. It's just not going to happen. And as a practical matter, counties are paying in the neighborhood of $175 to $425 an hour for these experts to do the examinations. And then ultimately, again, if they have to appear at a court hearing. So the cost to the county starts at this level. Next slide. So the question then becomes, why are counties responsible for this? Because ultimately, the state mental health hospitals where these people are ultimately going to go are state hospitals. Why should counties even have to pay for this at all? And the answer is, starts out as far as the examinations are concerned on the definition of what the director, you'll notice in the previous slide, I just said the court orders the director to appoint the 2 examiners. Well, who is the director? And the statute defines director in one of 3 ways. first, the director of a state hospital, second, the director of a local hospital, and third, the director of community services. And so it's pretty clear that when the statute was originally structured by the legislature, the thought was that ultimately the state would be handling this whole situation. The state director, the hospital director of the state hospital closest to the county would be doing the examinations, and they have psychiatrists on staff, and the $50 didn't become a problem because they had people on staff who were going to perform these examinations as part of their job. Well, that obviously didn't happen. Local hospitals have never gotten involved in this, even though directors of local hospitals are the second choice. So everything devolved down to the third choice, the director of community services. And the reasoning for that is because the statute says that director shall be defined, one of those three people, but as defined by the rules issued by the Judicial Conference, jointly with the Commissioner of Mental Health and the Commissioner of, at that time, the Office of Mental Retardation, now the Office of People with Disabilities, with Developmental Disabilities. And of course, that's a state agency. When they define the rules as it being the Director of Community Services, who would be the relevant appropriate director for appointing examiners. So now we've shifted a cost of the examinations from the state to the counties. Next slide, please. Continuing after that examination, the psychiatric examiners report back to the Director of Community Services. The director gathers those reports and provides them to the court to provide 6 copies, and there's all kinds of other side rulings, but basically the court reviews the report and decides whether or not they have to hold a hearing to determine if the person has capacity. And that can be done either based on a request for a hearing, or if the court deems it appropriate, or in certain instances it's required. But ultimately it's the judge, the court, that makes a decision as to whether the defendant has the capacity to stand trial or not. And if the judge finds that the defendant has the capacity, then the criminal process continues and it goes to trial without further ado. If the judge determines that the defendant is incapacitated, then the defendant is committed to the custody of the Commissioner of either the Office of Mental Health or the Commissioner of the Office of People with Developmental Disabilities, depending on what the mental issue is, whether it's an illness or a so-called mental defect. Next slide, please. If the charges are misdemeanors, basically the rules provide that the case gets dismissed, the person goes potentially into local treatment, although there's some constitutional issues involved here, which I won't get into, but basically there's no charge to the county, which is the end result that basically is most relevant for us this morning. The costs begin as if it's a felony charge, and at that point the defendant is ordered to a OMH or OPWDD forensic facility for restoration treatment. Now, really it's restoration services, because restoration simply means getting the person able to stand trial again. And in many cases, a person with a mental illness may perhaps be off their medications, and part of this restoration service would be stabilizing the person's medications, which may in and of itself make them have the capacity to stand trial. Oftentimes it's much more than that. The issue of timing involved here becomes very relevant, because we have cases where restoration could be 90 to 120 days. We have cases where it's more normal, where it's in the 6 to 8 month range. And there's also cases that have been reported to me from some counties where we've had people in restoration for 6 years. One county had up to 10 years. So, and you're going to see in a minute what these costs are when you get into the 10-year range. But prior to April 1st of this year, the practice was that OMH would charge only 50%, and costs have hovered in the recent past in the neighborhood of $1,000 a day for this kind of treatment. the counties had been paying 50% of that up until April 1st. As Kelly mentioned, as part of the budget assumptions this year, that was changed. So counties are now being charged 100%. And I'll explain shortly what the statute is behind that. But counties are now being charged 100% of the costs of the mental health treatment. We're still being charged 50% of the cost for the OPW, the treatment. But there are many fewer cases that go of treatment because somebody with a severe developmental disability is much less likely to require long-term. It becomes more apparent that they're not going to be restored a lot quicker. So the cost of those services tend to be substantially less. Next slide, please. And I just want to highlight that restoration is not treatment. Restoration, the stated goal of mental health treatment is essentially to provide treatment so that a person can ultimately reach recovery, giving them the opportunity to live as normal a life as is possible. It may require medication, it may require other therapies, but they can, live their life on a daily basis the same as all of the rest of us. But the stated goal of restoration is simply to provide services that will increase a defendant's mental capacity so that they can legally stand trial. We're only getting ready to put them back into the criminal justice process and to have them go ahead and be able to stand trial. Now, the reality and the sort of some of the fallacy behind some of this, in my opinion, is that you're normally facing a person who has been accused in most of these cases of a felony, many times a felony which amounts to assault or something else which would constitute, in pretty much anybody's opinion, dangerous behavior. You're talking about somebody who clearly has a mental illness, and in a civil situation, there is, under Article 9 of the Mental Hygiene Law, the ability to involuntarily hospitalize somebody who is mentally ill and they're in a situation where they might be dangerous either to themselves or others. By definition, if not 100%, many of these defendants would qualify for that criteria and would qualify for Article 9 involuntary hospitalization. If they were to be involuntarily hospitalized under Article 9 and referred to a state hospital, there would be no cost to the county. So we need to keep that in mind when we're developing solutions to this problem. And that's one of the things that that we need to really highlight. Now, the next slide, how severe is this problem for counties? And I think this is the impact that I think many of you are hopefully now aware of that you probably weren't in the past. There are 4 different forensic psychiatric hospitals that 730 defendants are generally referred to or ordered to by courts in the state, depending on what part of the state your county is located in. And the costs of the 4 differ on a daily basis a little bit. I said they were around $1,000. For Central New York, for example, it's $1,277.84. Mid-Hudson and Kirby are $988, and Rochester Psychiatric is $1,030. And those costs are figured each year by the state based on, I guess, the costs of running those facilities. So they do vary on a year-to-year basis, but they're hovering in this vicinity. So you were, prior to April 1st, your counties were paying 50% of those costs. I've just highlighted here just to give you some idea of what's in store here. 6 months of restoration treatment at Central New York Psychiatric Center is going to be costing the county $230,000 and change. And in the other areas, in the neighborhood of either $177,000 or $185,000, that's per person, and that's only for 6 months. If somebody is in for a couple of years, like 6 years, you can just multiply that out and see that that's in many cases a significant part of a county's budget. And the next slide, if you can please, gives you an example of some of these costs. Now, we did a survey, the conference did a survey of what costs were for counties' 730 expenses in 2019. And remember, in 2019, counties were only paying 50% of the cost. So the cost for Albany County, for example, was almost $400,000. For Oneida, Suffolk, and Westchester, well, Oneida and Suffolk were close to $2 million at 50%. I just picked out several different counties here, but some smaller, some larger, just to give you an idea that although the smaller counties may have fewer people and going to these facilities, the costs involved as a percentage of their budget are still very significant. And then if you double those costs, and you see in the next column what they would have been under the 100% rule, which we're now under, counties like Oneida would be paying close to $4 million, which I would venture is a significant percentage of the county budget. And it's impossible really to correctly budget for this, because you have no idea who's going to be arrested on a felony charge that might present in your county with a mental illness. It's not anything that anybody can really forecast. You can guess based on past history, but you really are only guessing. It's impossible to know what's going to be. So, to suddenly get hit with a $4 million expense for a smaller county in the state is going to be obviously of a significant problem. Next slide, please. Now, I said before I was going to talk a little bit about why counties are even involved in this situation. And under the law, it's the mental hygiene law, section 4303C. And that law gives the commissioner, both of the Office of Mental Health and the Office of People with Developmental Disabilities, gives the commissioner the authority to charge the county for the full cost of restoration services ordered by a criminal court. Now, this law goes back prior to the days of the unified court system. In olden days, the county courts, which are the criminal courts in most of the state, the county courts were really run by the county. Judges were paid by the county, and there was a county official. And so the thought of charging the county for services provided to a county court when it was really a county court made a little bit of sense, I suppose. Something, even though these people were going to a state institution where the state was providing this same care to other people at no cost. But the law has always been there that the county had to pay 100% of the cost. As a practical matter, during the period of time prior to Medicaid coming into effect in the 1960s, the major funding for mental health services in New York was provided basically on a 50-50 basis, where the state paid for 50% of the cost of the mental health services and the county paid for 50%. And it was called net deficit funding because the way funding was decided was a provider had to go out and raise as much money as it could to pay for its services. You would charge fees, if you could, to the person who was receiving the service. You might do fundraising, you might get grants or something from other sources. And whatever deficit you had in your funding, the difference between all this money you could raise and what your actual cost was, that was your deficit. And that deficit would be picked up 50% by the state and 50% by the county. And that was the norm up until Medicaid and Medicare came into effect, where all of a sudden there was a federal share, and that kind of changed the whole system. But this 50-50 concept was, in this case, continued on up until April 1st of this year, of 2020. And what the Division of Budget did this year was simply change an assumption, because the law was already there. It did not require a change in the law. It merely required a change in the assumption made by the division of the budget for the OMH budget, that from now on, they were going to assume that counties would be paying 100% of these costs, as the law said that they had to do. And from then on, that would be the case. So as of now, since April 1st, if a judge in your county orders somebody to get restoration treatment under Section 30, the cost of that treatment, the $4 million or $2 million or whatever it amounts to be, will be a cost to the county. And it will come out of whatever part of the budget, however you do your financing, but ultimately it's going to be a county expense. This is clearly, I think we've made the case, it's clearly a major issue for counties that we have to be looking at and seeing what kinds of things we might be able to do in order to solve some of these problems. Before we get to that, however, next slide, please. I do want to point out that in addition to Section 730, there are two other sections of law that also come under the same section, that come under this cost allocation section of mental hygiene laws, 4303, and that is Section 322.2 of the Family Court Act, where a potential juvenile delinquent is suspected of lacking capacity. The family court judge can order the same kind of psychiatric examination with the two examiners. Those costs are also passed on to the county. And ultimately, under Correctional Law 508, Section 508 of the Correctional Law is the hospitalization of pre-sentenced people in local correctional facilities. So if you have people in the jail who need mental health hospitalization, who are not sentenced, who are waiting trial or under a civil commitment or some other basis that they have not been sentenced, there is a provision under that section of the correctional law for sending those people to state hospitals. Now, and this is my opinion, my legal opinion, the state has been charging for 508 patients in the same way as they charge for 730 patients. So if you have, if your sheriff is sending somebody to a state hospital, either the sheriff or your mental health department, however you budget in your county, is getting a bill for 100% of the cost of that 508 hospitalization treatment. Now, if you read Section 508, it talks about 508 as being a civil commitment, similar to the Article 9 commitment that I mentioned at the beginning. So any mentally ill person who meets certain criteria can be ordered into mental health treatment at a state hospital, for which the state is 100% responsible for the cost. Whereas Section 508 patients, even though it's essentially a civil commitment under the statute, the state has said that because they got to jail based on some kind of a criminal court order, which may in fact not even be the case, because there are people who are civilly committed to jail who would be under this situation. But in any event, they're saying because the judge has put this person in the local correctional facility, therefore that constitutes the court order. Now, what I neglected to highlight in the previous slide. Can you go back to the previous slide for a minute? What I neglected to highlight is if you look at Section 4303 of the mental hygiene law, it says that the commissioner has the authority to charge the county for the full cost of restoration services ordered by a criminal court or the family court, it goes on to say. So that those two are clearly legally, I mean, under current law, the state can legally charge the county for those ordered into restoration by a criminal court or by a family court judge. But next slide, the correction law, the 508 charge is not ordered by a criminal court, and therefore, in my opinion, should not be subject to this. although the state has in fact been charging. Next slide, please. Now, the last thing that I want to just bring up with you, and then I'm going to turn it over to Sharon, is why the state can't change the law. And Kelly sort of highlighted this at the beginning, but just to bring you up to date here a little bit, in the, I don't know, 12 or so years that I've been around, and for probably 10 or 12 years prior to that, the conference has been seeking legislation essentially to do away with Section 4303 altogether, so that the counties would not be charged anything for any of these defendants. And then we ultimately tried to compromise and to say, well, we would pay for 30 days, but beyond 30 days, it would no longer be a county charge. None of that has gone anywhere. We've had some support in the legislature, but not enough to ever get it passed in either house. And ultimately, our major lobbying this year was, as Kelly mentioned, Kelly and Courtney were very instrumental in lobbying to overturn the DOB decision to charge 100% of the cost, to move it from 50 to 100. Probably, I don't know, we may have even been, I'm just guessing, but obviously COVID, when COVID shut down everything, that kind of, we were making a little bit of progress, I think, and then when COVID came in, it kind of shut down everything. So it didn't happen, and so therefore we're stuck with what we're stuck for. The state obviously was looking to shift expenses, and the reality is neither the legislature nor the executive are, given the problems that the state is having with its budget, are in any way going to be helping us, certainly not in the near future. So the issue at this point in time is we have to look to ourselves really to come up with a solution for what we can do to minimize the cost. So we need to address some of these concerns, and I'm going to turn it over to Sharon Mcdougall to discuss with you some of the issues that some of the things that we think counties can be doing, should recognize, and also things they can be doing. Sharon?
Next slide. Thank you, Jed. I really appreciate, and I hope everyone sees some great value in Jed's legal perspective overviewing this law and the effect of it. So that's going to be something key, is really understanding. Needing to address these concerns on how to handle the 730s, as Jed just indicated, is really going to be more of a local solution at this point. Not that the Conference of Local Mental Hygiene doesn't keep their lobbying efforts going with our state partners, but this local solution to address the concerns is going to be increasingly key moving forward. And that's what a group of us have been working on, and I'm going to get into some more details. You can see some of the rates here of how the restored defendants pleading it down to a misdemeanor in some of these cases can be very valuable. And the misdemeanor allows some treatment to be linked instead of someone at a state psych center just getting restored. Judges are going to be really key here as far as signing those 730 orders and sending someone to mental health treatment. Restoration is not treatment, and I think that's one of the key parts we've found as we've talked to a lot of local officials and local judges, is this desire to get defendants who need mental health treatment to treatment, and to help clarify the fact that a 730 really isn't the mechanism for that. And budgeting these locally is going to be a key problem. We know that restoration expenses, as Jed just shared, those are going to be extremely high, as you can see. You can just imagine how that's going to expand out. Finding a way to balance those expenses and try to get anyone who's mental health into some sort of support. Highlighting that Article 9, Jed really emphasized that a number of times, because the Article 9 gives much better strength to get someone who needs treatment into treatment locally. That's a better way for absorbing those costs. And again, those end up being state costs, not directly charged back to the county. So I just want to highlight some of the things Jed talked about. Next slide, please. So getting into local solutions, I know this is a big part of the concern, and we're trying to find ways to help. There's a number of focuses that we've found really beneficial. Diversion is key. And I think the wonderful part about this is the intention behind a lot of the 730s was to try to divert our mental health from criminal justice into treatment, but that's actually not the correct source. So we want to help people understand Article 9 in civil commitment is a more appropriate way of getting someone into treatment and at state costs. Law enforcement is part of this, our legal services at the local level, our judges, helping the community to identify alternatives to divert anyone from criminal justice into these other supports at the local level, or Article 9, civil commitment, if that's more appropriate. Education is going to be key. One of the things we found is a lot of misunderstanding about what a 730 does and doesn't offer our mental health defendants. So all stakeholders at the local level really are going to be needing a lot of education about this law. The more we understand locally about what restoration treatment is and the costs associated with it, can help to avoid inappropriate use of the 730 at the local level. It really has to be a community-wide effort. Again, all stakeholders are in some way involved with this, and the more that people understand alternatives to this law, the better we can help at the local level. Some other solutions are really key here about communication. All departments of your county really need to try to find ways to work together to find the right solution that matches your county, matches the communication that you already have, and also helps to communicate with our state partners at OMH and OPWDD to make sure that any services are not misused, that we're not inappropriately placing someone on 730 restoration. But that communication within the county, you know your county's best. You know what works, what communication's there, or maybe what is missing at your local level, where you need to improve some communication or get the correct stakeholders together so that they can start communicating in more thoughtful ways. That charging is the last point here about law enforcement. They're sort of the first initial step with our mental health when it comes to the legal system. If there's any way to avoid and divert from charges, if that's a possibility, that's something that the DA can coordinate with. There's a lot of law enforcement interactions at the local level with mobile crisis teams, with CIT team models. Those can really help to thoughtfully avoid charging our mental health defendants. Next slide. So again, I want to highlight the key partnership, the local solutions. Communication within the county between our district attorneys, our public defenders, the local courts and judges, and especially the court clerks, and the mental health director, the director of community services. The more you can get these parties to communicate at the local level and partner together on local justice committees or any other alternatives to incarceration committees that might be started in your county are really key. These are the people who can find individual solutions in really tough, high-risk cases where someone's ending up in your legal system. These are the people that are involved in a lot of the alternatives to incarceration and communication at your local level. They can be absolutely key. Opening up the communication stream between these partners at the local level are really going to help you to avoid 730s and increase costs associated with it. Next slide. So what is the work we've been doing? So huge kudos to Courtney David, who's been helping to coordinate this work group of 16 counties behind the scenes and getting us all on the same page as we share efforts of what every county's been doing and share communication about 730s and ways to approach this at the local level. Since we know we don't have a state partnership correction at this point, we're still leaving that on there though. OMH's partnership with the Conference of Local Mental Hygiene Directors has been key. They're continuing that communication to try to get us information from the state psych centers when someone is placed there. And the Conference of Mental Hygiene Directors helps to really advocate up on behalf of all the counties and the directors of community services. I know they're going to continue that effort. We just know that that's not a solution right now as far as the 50% costs. It's going to be 100% to the county. So focusing on the other parts. So this slide shows you the actions on the far left, the actions that we're really focused on for local solutions. The center shows you some of the intercepts or the interventions that we believe counties can utilize at the local level in order to start finding different ways to intercept, to avoid having a 730 as much as possible. And the far side on the green shows the resources and the supports that the work group is working to develop to have shared with each of the county. We have 2 more months to the work group, and these green sections are some of the areas that we're really focused on and developing resources. The collaboration between this work group has been amazing. You would be shocked to see the individual county ways that they're trying to help get our mental health defenders into treatment to avoid high costly 730 placements. We're finding that those resources and those local corrections and those local communications are exactly the resources that counties need. What we're planning to do is put all of these resources together so that we can share those and focus on some information all the counties can use to divert from 730s, to adapt to 730s, and to help with developing county-wide partnership at the local level. Just to highlight a few of them, I have to emphasize the second green square down, the process map. As Jed just spent the last 30 minutes processing this law and the nuances and the super specific issues that come up with this law, understanding that process can be really complex at the county level, especially if you have a new judge or a new DA. This law doesn't come up much, but when it does, it can be very costly. So we want to develop sort of a process map, kind of the lay of the land of how this works at the county level, so that any new DA, new DCS, anyone new coming into the county has a resource of how a 730 works. Again, highlighting the specifics of what Jed just explained of how complex this law can be. As the work group ends in October, we hope to finalize all of these resources and be able to share that through the Conference of Mental Hygiene Directors with each of the counties. Next slide. So I want to end with emphasizing alternatives. Again, highlighting the point that Jed made earlier, 730s are not treatment. They're not true alternatives to incarceration. There may be a pause in the legal process, but they come right back to your legal county to process. They're not treatment. They're not true alternatives to incarceration for our mental health defendants. The local landscape is obviously changing a lot with some of the legal things that are happening, from bail reform to raise the age to the racial justice issues that we know are affecting all the counties right now. Finding ways to partner together and develop local alternatives to incarceration are really going to help you to adapt and ease the local stress and costs to your counties. Most counties out there have various justice collaboration groups that have worked in their community to develop various ATIs, such as mental health court, such as reentry programs to help reduce recidivism. Some of the PIN's diversion. There's also mental health laws, such as AOT, that could also be a help, assisted outpatient treatment, to help monitor someone who's repeatedly entering our legal system. As far as law enforcement in that first step, even trying to avoid charges in the first phase, we find the CIT models working with our mobile crisis team at the county levels are really supportive and help to engage legal with the mental health diversion efforts that might be available in your county. Local officials, we really encourage you to collaborate together. There's so many local solutions that we've found in the work group that have really benefited counties to avoid having to use a 730 or to resolve into a 730. Really find some ways to develop those alternatives to incarceration and encourage your key partners, your courts, your DCSs, your mental health. Encourage them all to work together to help develop those. We hope that those local solutions are really going to help. So I'm going to end here, and I think we're heading into question time. Correct, Alex?
Yes, thank you all so much. So we do have quite a few questions from our audience. Thank you all so much for that presentation. It was very informative. The first question we have is whether the PowerPoint will be made available, and yes, it will. We will share a PDF and recording of the presentation after the webinar. You can find it on our website at nisac.org/fall seminar. The second question we got is, who decides whether the case goes to OPWDD or OMH? The person who wrote in notes that the judge usually doesn't make that call, they just deem the person unfit to proceed.
Well, it would depend on, based on the examinations, it would depend on what the disability that the examiners found. If the examiners found that it was a developmental disability, then it would go to OPWDD. In the majority of the cases, I don't know the specific numbers, but in the majority of the cases, it's mental illnesses are involved, and those will go to OMH.
The next question we got is, what happens if there is a disagreement about whether or not a person is restored?
Well, ultimately, it's everything is done by court order. So ultimately, at the end of the day, there's several issues here. One is if the state doctors, the doctors at the state forensic facility deem that the person is restored, they still have to ask that the defendant be brought back to court. They'll report back to the court. The judge will hear what they have to say and why they think there's restoration. If anybody disagrees, and it's like the district attorney or the defense counsel disagreed with that, then they can request that the court hold a hearing on that. Ultimately, the court makes a decision. The local court makes a decision as to whether or not the person is restored. If they do not believe they're restored, then they send them back to the state facility for further restoration. There's also provision in the law that it has to be reviewed initially on a one-year basis. If the person isn't restored in 1 year, the court still has to review it, and ultimately if they feel that further restoration is needed, they sign what's called an order of retention, which ultimately after the first year can be for up to 2 years to continue those services. But if it comes a point that restoration is not going to be likely, I mean, if somebody's been in restoration for a long period of time and it's apparent that, well, I shouldn't say, if it's thought by some people that the restoration is never going to occur, that person's never going to have the capacity to stand trial, then there is a procedure based on a United States Supreme Court case called Jackson against Indiana, which held essentially that you can't hold somebody in restoration for longer than a reasonable period of time to have them restored. If they can't be restored in a reasonable period of time, then either they have to be discharged or they have to be committed on a civil basis, in our case under Article 9. So there's a lot of different, the answer to that question is it sort of depends on how it gets back, but ultimately the decisions are made by courts. So it's the judge who has the final decision on all of those issues.
Thank you. As a reminder to everybody watching, you can type in your questions on the questions panel on the side of the GoToWebinar platform. We'll do a couple more. We have some time at the end here. The next question we received, is there minimal time that these psychiatric evaluations must take? And what happens if the defendant refuses to participate? Can the evaluator review records without an in-person evaluation?
This is the first part of that question is there's no specific time set in statute. I mean, it's up to the examiners. Essentially, I'm told, and I don't know this, we've never done a scientific survey, but I'm told that an examination generally is around 2 hours, but that's for cost purposes. If you're paying by the hour, you obviously have to keep track of those kinds of things, but there's nothing that absolutely provides it. The second part of that question is getting more and more complicated because under the laws prior to bail reform, oftentimes 730 defendants would be committed to the custody of the sheriff or the local correctional facility and held there, and then the examinations would take place there, and it was easy to find them. The statute says that if the defendant is held in custody, then the examination would take place where they're held in custody. If they were out, and now theoretically all defendants are, unless they're accused of one of the qualifying defenses or one of the qualifying offenses under the bail reform law, they would be entitled to be released. Now you have to find them. So in some cases that's becoming problematic. DCSs are having trouble because they're not really set up. I mean, mental health services are not really set up to find people and whatnot. So it's problematic. There is a provision in the statute, and again, I mentioned the way the statute was set up, it anticipated essentially that the state hospital directors were going to be the ones doing this. But there is a provision in the statute that says that if the director deems it necessary to hospitalize the defendant in order to do the examination, which is exactly the kind of case that this questioner is referring to, you can't do it. You need to bring them into a hospital where they have the facilities to kind of be able to treat the person or know enough about how to treat the person to be able to do an examination. That would be the obvious optional way to do this, and probably the optimal way to do it. But the problem, of course, is DCSs have no authority to require a hospital director to take somebody into the hospital, and getting someone into a hospital in and of itself is, because there aren't that many beds available, would be difficult. So, I mean, the legal answer to the question is that person should be hospitalized. The practical answer is we're running around, and there are a couple of jurisdictions. There's a court case in Brooklyn and another one up in Albany that have held that it is appropriate, and I'm not sure I agree with the legal reasoning in either of these cases, but they have held that it is appropriate to commit a defendant in need of a 730 examination to jail, and hold them there so that they are available for the examinations. And they use the reasoning that holding somebody in jail is pretty much the same as holding them in a hospital, which I personally would take issue with, but those cases are out there. So there are some counties that are actually holding people in jail in order to avoid the problem of finding defendants. I think that's somewhat problematic, and I haven't seen it come up on an appellate level yet. I mean, I frankly would argue from a legal point of view that hospitalization is not the same thing as jail, but that's what the law, that's what the law is, at least in those jurisdictions at the moment.
Thank you. Another question, does the conference have historical costs for all counties that we could share with our membership?
I'll take that one. Yes, we do. And in fact, what we have as part of our lobbying efforts, we have data provided to us by the DCSs for every county, number of 730s, broken down by OMH 730s and OPWDD 730s. And so I think we have up to a 3-year trend right now, and I'm happy to send that over to you, Alex.
Thank you, Kelly. A follow-up based on your comments about your advocacy. Has there been any outreach to the State Magistrates Association?
We are, from an advocacy standpoint, no, we focused on the legislature. From an education standpoint, we're in the process of connecting with those very important people in this process, both the judge and the County Clerks Association. So we're connecting with them through the education piece.
Great. Another one, if a case is reduced to a misdemeanor, but the person is found incapacitated, then would the court need to dismiss the case? And how would treatment be linked in this case?
Yeah, the statute actually says that if a person is found to be incapacitated on a misdemeanor charge, then there's supposed to be what's called a final order, which is an order which dismisses the case to the point where it's with prejudice, so it can't be brought again. And the person is supposed to be committed to the custody of the commissioner for 90 days. There's a Westchester court case from several years ago that held. Dr. Searles was the commissioner at the time, so we're talking more than a few years ago. The court held that that was unconstitutional. It was never appealed. So as a practical matter, the defendant, OMH, has taken the position that when those people are committed to their custody, they're kept for no longer than 72 hours, which is what you can hold under Article 9 anyway, and that hopefully connected with further treatment, but they're not really held in custody any longer than that.
Mm-hmm. When the 730s, when we have 730s rather, the charges are usually violent felonies that leave victims behind. How do defendants remain hospitalized before they are released? Is this different from an involuntary commitment where the person is at most kept overnight before being released back into the community? And how can we assure victims of crimes that their safety will be preserved?
That's an excellent question. That's one of the things that we have to be working to. The underlying problem is there's not enough room in our hospitals, especially with the fact that hospital beds in the state, psychiatric hospital beds in the state have been reduced substantially. I have another slide when I do training for community services boards that shows that, in the 1950s, we had over 90,000 hospital beds statewide, and over the years, it's been reduced to there's approximately 2,500, state hospital beds statewide, and I think there's 500 or 600 that are dedicated to forensic. Don't quote me on the numbers, but it's in that vicinity. So there aren't a lot of hospital beds assigned for people with mental illness. Getting people in, in the local level, we have to be working better to develop diversion programs that sort of meet this need, and I think that's really what Sharon was talking about. If we can get people into programs, when police take defendants to a hospital on a psychiatric basis, you're right. What often happens, because the ER, emergency rooms are overflowing as it is, they don't really have the capacity to deal with these people. We need to have centers like that people can be brought to, really psychiatric emergency rooms. We need more of those, and that's a state, that's going to be a state issue, but we need more psychiatric emergency rooms to bring people to, in order to, have this space to hospitalize people. We would need to give other people the authority to require, if somebody was brought to a hospital and they went through the normal Article 9 proceeding, where if they had to be seen, they're going to be kept generally for at least 72 hours. If the appropriate proceeding is brought, they're going to be examined by a psychiatrist, and if it's necessary on an emergency level to keep them, they can be kept up to 15 days before any other, proceedings are brought. And then, if it's decided by a court that they should be involuntarily hospitalized, it can be, for substantially longer periods of that. If we can get ourselves into really using that system, I think, a lot of the problems that this questioner is bringing out would be better. And I think that's sort of what we're working towards. We've got to get all of our community partners involved in the situation in order to be able to help. Local hospitals have to be part of the solution. We need everybody. We need the judges, we need the DAs, we need defense counsels, we need the clerks, everybody's got to be part of this problem. And we're hoping, as a result of this proceeding, that we've put forth a case, especially to county administrators, county executives, and those people who have some authority to bring people together to make this a major issue, to say, yes, this is a problem. It's not fair to law enforcement to say, bring this person to a hospital time and time again and see them back out on the street in 10 minutes. That's got to be deflating. They've got to know, law enforcement has to know that if they bring somebody in, something's going to be done and they're not going to see that person out on the street again in 10 minutes. DAs have to know that, if they're not charging these people and putting them into jail, that they're going to be treated in a way that is going to keep the community safe. These are all very legitimate concerns, and each of these different partners has a different concern. So we need to come together as a community, all the stakeholders, and develop solutions that work. And they're going to be different. Like what's good in one county is not necessarily going to be good in another county. In some cases, with some of the smaller counties, there may be regional solutions that are better, or 2 or 3 counties, because there's not enough people in any one county to be able to support it. But if you can get a couple of counties together and each contribute, you can do something. So the solutions are what we're working on and what we need to. I know that's not a full answer to that question, but that's the purpose of, frankly, this, at least what we're trying to do from the conference's point of view. And hopefully we'll have the engagement of all of our community partners, not only the mental health people, but everybody, to move forward from there. I don't know.
Thank
Sharon,
you. If I could add to that, Alex, if you don't mind, I think Judd's description is a good illustration of how complex these cases are. And we hear from our members of very violent, very serious cases, very serious charges that are similar to, what was described by the individual who was looking at this. But I think part of our overall effort here is for everyone who is involved, all parts of the county, the DA, the public defender, the judge, to have a good understanding as to what all this means going forward in terms of impact to the county as one consideration, while trying to balance all of the other considerations, public safety, the actual crime that was committed. And while we hear some felony charges with very serious crimes, we also hear of cases from folks where individuals are referred for 730 who do not need a 730 and instead could have been referred for services or charges dropped, misdemeanor. So it's very unique cases, but hopefully this will help start the conversation locally so that everybody knows what exactly they're dealing with in the larger picture when those decisions are made.
Thank you, Kelly. We have more questions pouring in, so I'll ask a few more with the couple of minutes we have remaining in the webinar. This is for the whole panel. Can you speak about efforts for jail-based competency treatment?
Which one of us wants to take that? Do you want me to take that? Okay.
Sure.
This is a legal piece, quite frankly, and Jed can add to this. The state in the past has put forward a proposal to allow jail-based restoration, competency restoration. The conference's position has been opposition to that for a couple of reasons. Number one, jails are not hospitals. They're not built to do that. And we don't think that that's a real therapeutic place to try to restore someone to competency. from a functional, and the Sheriff's Association also opposes this, and they didn't give this year's budget, they included something, but they didn't give you any money for it either. So how would you retrofit a jail to do this? And the bigger piece is the legal piece, which under New York's Constitution, you cannot medicate over objection. And the state psychiatric centers have issues with this as well, meaning, the biggest part of restoration, I think what folks here would tell you is it's getting people on medication and getting them stabilized. And you can't medicate over objection in a jail without having to go to court to do that, because under our New York's Constitution, it's a violation of the individual's due process. So even if people wanted to do it, which they don't have, the authority to do, that the Rivers case, the medication over objection, is a brick wall in terms of because it takes the most generalized and effective tool out of the toolbox to be able to do that. Jed can comment more. I'm channeling you, Jed. I hopefully have listened well enough.
The Rivers requires you have to be in a hospital to do medication over objection. So
right,
jails are not hospitals, and the sheriffs have been against this, generally too. So trying to put something in a jail when the sheriffs are against it just doesn't make, it's not going to happen. And thirdly, the issue. There is a provision in the law that allows restoration to be done on an outpatient basis. So if you had people that were in jail or that are now released under bail reform, you could actually be doing outpatient treatment, outpatient restoration. That could be an alternative, which would obviously not be as costly to the counties. But in order to do outpatient treatment, you have to have the consent of the district attorney, and up until now anyway, district attorneys generally, and I know the District Attorneys Association has been against it because I've talked to them about it, but I don't think there's any district attorney that's ever given consent. I have been told, let me put it this way, I've been told that there are no district attorneys that have ever been given consent. So that's not likely to happen. There was 2 years ago, there was one proposal to do jail-based restoration in Westchester County that they had sort of worked up. And at that point in time, the state was potentially going to give some money to set that up. And then it fell apart. And then when it came around this year, they wanted to do jail-based restoration. They wanted the county to pay for it. And there weren't any counties that were interested in it.
I would just have to share one last comment there. I think we ask our local sheriffs and our local jails to do way too much already. Asking them to restore someone to competency at a local jail, I mean, that's just one more thing that they were never developed for. They just don't have the capacity for. And I think we have to think of a solution in a different way, in a better way.
Thank you. We have time for one more question. This one comes from Cortland County, which recently joined NACO's Stepping Up initiative to do everything they can to keep people with mental illness out of their jail. They would like to know if the panelists have any experience with this initiative and if they find it useful in communities across the state.
Sharon, you want to take that?
I'll take that one.
Yeah, I was going to say, Sharon, you take it.
Stepping Up initiative is a wonderful initiative. If your county hasn't heard of it, you should definitely go to the website. It actually has an entire toolkit for counties to use. The Stepping Up initiative is really focused on a national effort to try to help divert our vulnerable population, our mental health, our people with developmental disabilities, people with addictions, out of the legal system and into treatment. It does a lot of focus on alternatives to incarceration. It's an amazing program. They actually walk your county officials through everything from a proclamation to resolutions to a toolkit that your Justice Center committees can utilize to try to help focus on alternatives to incarceration. I have been involved in it in previous counties. It's a wonderful opportunity. I'd encourage any county officials to look at it. They partner very closely with counties and really help you give give you all the resources that you might need or you might be looking for. So I'd encourage going to their website.
Excellent. Well, thank you to everybody who attended this virtual fall seminar workshop about counties' mental health and the criminal justice process. And a special thank you to our speakers, Kelly, Jed, Sharon, and Courtney for joining us this morning, and also to our sponsor, Labella Associates, for sponsoring this session. You can find a recording of the webinar and a copy of the slide deck on our website at nisac.org/fall seminar. We hope we'll see you all at 2 p.m. for our next session about meeting New York State's climate and renewable energy goals. Thank you again to our panelists for joining us very much. Take care, everyone.
Thank you. Pleasure.
Stay safe, everyone.
Thank you.